Hi, I'm Martin Gringer with the law firm of Franklin, Gringer and Cohen in Garden City, New York. We've just given a presentation on the issue of joint employer status, or as I like to call it, trying to avoid being an employer. And what we have found over the years is that companies, like being the boss. They like having the control. They like people following your instructions. When you say jump, people say how high. But they don't always want to have the responsibility of being an employer. They don't want to have to deal with unions. They don't want to have to deal with negotiations, arbitrations. They don't want to be sued for discrimination or wage and hour violations. So they use various mechanisms to try to avoid being responsible. They want to have their cake and eat it too. They want the control, but they don't want the responsibility. And one of the ways they do that is by using contractors. They might use a staffing agency, which may promise them that they're not going to be sued, that they're not going to have to deal with labor relations. They may use a cleaning contractor if you're a landlord or a factory, so that you don't have to have a staff of maintenance employees. And sometimes franchisors try to avoid employment issues by having franchisees have all the employees. And for a long time, this worked very well for these companies. They were able to have their cake and eat it too. But it's a trend that's changing. And companies are being held responsible in situations nowadays where years ago they were not. We see this in wage and hour cases. The laws evolved over the years. Originally, the courts would only look at what they called formal factors of control. Whether they hired, they fired, they disciplined, they did the interviewing, they set the rates, But now, the test has evolved to something that's called functional control. And sometimes it's called the economic reality test. Who's the real employer here? So if you have a staffing agency that provides employees to any kind of business, and it's the staffing company's not providing day-to-day supervision, and it's the customer that's providing it, and they treat these individuals no different than their own employees, and they tell them what to do, and they evaluate the work. That company is going to be held to be a joint employer with the staffing company. The staffing company may sign the checks, they may provide the benefits, they may do the hiring and interviewing, but if the day-to-day supervision is provided by the customer, that company is going to be a joint employer 9 times out of 10, maybe more than 9 times out of 10. So that avenue is shrinking, and companies need to be aware of that. And last year the NLRB, National Labor Relations Board, came down with a decision, Browning Ferris Industries, where again you had a staffing agency that exercised all the indicia of formal control, and Browning Ferris had exercised some control. There was a cap on pay rates because they didn't want the staffing company employees to get paid more than its own employees. There's certain hours they could work because Browning Ferris determined the hours that its facility was open. And that and a few other factors, the board concluded that Browning Ferris and Leadpoint, the staffing company, was a joint employer, and that a union could try to organize those two companies in that bargaining unit in that facility simultaneously. And the National Labor Relations Board, this is important because they want to have a situation where you can have meaningful bargaining. If you have an essential player that's not at the table, it's hard to bargain a contract. So what the NLRB is doing is saying, we want everyone to be at the table. So, and this is part of a trend. Another way companies try to avoid having an employment relationship is by labeling workers to be independent contractors. And again, that's not going to work the way it did in the past. You know, like I like to say, if it looks like a duck, walks like a duck, talks like a duck, it's a duck. So if your people are doing things employees do, and they work for you, they come in every day, they have hours, they're going to be found to be employees. You know, basically, you have to be sure to be found to be an independent contractor. You have to be in business for yourself. You know, you have other customers. You hire your own employees. You set your own hours. You know, so that's something that's shrinking. So we're seeing this in wage and hour cases. We see the Department of Labor doing unemployment audits. They're finding these people who used to be found to be independent contractors to be employees. So basically, you can't have your cake and eat it too. You know, if you have the control, you're going to have the responsibility as well. And chances are you're going to be an employee with all the responsibilities attached to that.